what we want to talk to you today about is predominantly two recent appellate judgments in the field of sex discrimination. I'm going to talk to you firstly about the recent Court of Appeal judgment in Geldart, which happens to be a case that I acted in. And Anna, after that, is going to speak to you about Price and Powis, which is concerned with shared parental leave pay and whether there's any scope for any kind of sex discrimination claim there on a different footing from that which was considered in Ali and Capita and Hextall and Chief Constable of Leicestershire. Price concerned comparison with adoption leave and the pay pertaining to that. But as I say, I'm going to deal with Geldart first, which is in some respects a fairly unusual case. It's important to keep in mind that it's a police case, so there's no traditional employment relationship at issue. As you'll probably be aware, the sort of employment relationship or contract in inverted commas for police officers consists essentially of the police regulations 2003 and various Home Office determinations which provide interpretation and clarity, further detail in relation to the various regulations. Mrs. Geldart was herself a police officer, so when she took her maternity leave, she took maternity leave that was provided for under the police regulations, not under the Employment Rights Act, the usual employee statutory maternity regime. Again, of course, her maternity pay was provided for under the police regulations, Regulation 29, Annex L. So she received, in her case, 13 weeks of full pay and 10 weeks of half pay. So the usual amount is 18 weeks of full pay, but there are other special provisions which enable you to extend the period of pay by accepting a half rate for some of that period. Officers in Central London forces, City of London Police and Metropolitan Police also receive what's called a London allowance as part of their general remuneration, but that allowance is found in a different part of the police regulations from the part of the regulations governing pay. So as you'll see from the slide, the part pertaining to maternity pay is found in Regulation 29 and Annex L, which is in Part 4 of the regulations. It's pay as defined. London allowance is in Part 6, which is a totally separate section of the regulations, and London allowance is something that's received as a recruitment and retention incentive. It's separate and distinct from London weighting, which is an uplift to the pay that an officer receives. So it's a fixed amount, and it hasn't changed for some time. It doesn't fluctuate in line with the officer's basic pay. So the issue in this case was that as Mrs. Geldart progressed through her maternity leave, and as she moved down to half pay at 13 weeks, City of London Police also reduced the amount of her London allowance pro rata in the same way. And then after 10 weeks of half pay had elapsed, so that she went down to simply statutory maternity pay, her London allowance was reduced to 0. And the contention was that actually on a proper construction of the regulations, London allowance simply remained payable at all times, except where other specific provisions facilitate its cessation, and that shouldn't have happened, and that the reason why it happened, the criterion that was applied in order to decide to stop Mrs. Geldart's London allowance was the provision of the maternity pay part of the police regulations, so Regulation 29 Annex L. So after 13 weeks of full pay, London allowance is then reduced in half. So the criterion, we said, for deciding to reduce the London allowance was 13 weeks of maternity leave. That is a maternity reason for the treatment, and therefore is direct sex discrimination. So again, due to the case being a police case, it's complicated by the fact that Section 18 wasn't available to Mrs. Geldart. Section 18, as you may know, is predicated upon the Employment Rights Act maternity leave and pay regime. So with the exception of the first 2 weeks of Mrs. Geldart's maternity leave, which is the compulsory period of maternity leave, in respect of which she could have used Section 18, but which she suffered no loss in relation to, subject to that, if she couldn't use Section 13, she wouldn't have had a direct sex discrimination claim. So in the tribunal, the core question was, well, can she use as a police officer Section 13 instead, adopting the pre-existing position as it had been prior to the advent of a specific protected characteristic of pregnancy or maternity. So using the old ECJ case law, Webb and EMO Cargo being the culmination of that line of authority. So we said the reason is maternity. Section 18 didn't purport to change the law in any way. It simply provided an additional supporting mechanism for pursuing pregnancy or maternity cases. There's nothing to stop someone in Mrs. Geldart's case from using Section 13 instead in the sort of traditional way. EAT agreed with that. The tribunal, agreed with that. It also agreed with the construction of the police regulations that London allowance was payable at all times. So there was no basis for reducing and stopping London allowance. That amounted to a detriment. And the reason for the detriment was maternity, because of the criterion that was applied, namely the provisions of the maternity pay regime in the police regulations. The tribunal considered that the reason for the treatment wasn't in dispute, that there'd been no meaningful dispute of fact at first instance about why all of this had happened. The respondent's case was that it had treated London allowance in the same way as pay. It had applied the maternity pay provisions of the police regulations in deciding to reduce and then stop London allowance. So that being the case, the tribunal regarded it as a straightforward case of direct sex discrimination. There was, in the alternative, an indirect discrimination claim pleaded. Perhaps somewhat unhelpfully, the tribunal didn't go on to address that claim in the alternative so as to provide an alternative basis for its decision. It took the easy route out, which was simply to dismiss the indirect discrimination claim because the direct claim had succeeded. So unfortunately, that meant there was no alternative reasoning to rely upon for the purposes of later appellate judgments. So the force, the commissioner appealed against that judgment. In the EAT, the tribunal's judgment was upheld in its entirety. There had been an argument at first instance of a jurisdictional nature that this claim was truly an equal pay claim and not a direct sex discrimination claim. So, and because no equal pay claim had been pleaded, the force had sought to argue that the claim was simply excluded and that was the end of the matter. But the tribunal had said, well, that doesn't make sense because an equal pay claim is a claim where the man, for instance, has a term that the woman doesn't have, or both parties have the relevant term, but it operates more favourably for one sex in comparison with the other. This was not that sort of case because the issue was that the police regulations did provide for London allowance to continue being paid. It was effectively a quasi breach of contract case, it wasn't that the term didn't exist or that men were entitled to London allowance and the claimant wasn't. So it wasn't an equal pay case, and there was no appeal against that conclusion, so the EAT didn't have to consider it. The EAT upheld the reasoning that there was no comparison required, even though this was a Section 13 case, not a Section 18 case, applying the traditional law in the form of the ECJ judgments culminating in Webb and EMO cargo, as I've previously mentioned. So that point of law was quite firmly established in the EAT judgment, that nobody is confined to Section 18 if they want to bring a pregnancy and maternity case. The only requirement is that the treatment must occur during the protected period. So in Mrs. Geldart's case, that's the period of her pregnancy and the maternity leave provided for under the police regulations. So on that proviso, Section 13 direct sex discrimination cases are available in the alternative to Section 18 claims. EAT took the view that the reason for the treatment had been conceded below, as the tribunal had recorded. There wasn't any meaningful dispute about that. Everyone knew factually what had happened. So again, the EAT regarded it as a fairly straightforward case, because the reason it considered was self-evidently maternity, and therefore the tribunal had been right to uphold the claim of direct sex discrimination. There was a cross appeal on the tribunal's dismissal of the indirect claim, but that didn't arise because the EAT simply upheld the tribunal's order, so that claim remained dismissed at EAT level. Again, no alternative reasoning, no consideration of that claim, unfortunately. So then we get to the Court of Appeal, which is what we're mostly interested in this morning. The Court of Appeal took a different approach from the two previous levels of judgment. So on the first point, however, the Court of Appeal was satisfied that the construction of the police regulations as to the entitlement to London allowance, the quasi-contractual issue, that construction was correct. It was right to say London allowance simply remained payable at all times unless there were other specific provisions determining that it should not be paid. No such provisions applied in this case. So Mrs. Geldart had wrongly not been paid her London allowance in full during her maternity leave. However, the Court of Appeal considered, Lord Justice Underhill this is, that the tribunal and the EAT had taken a wrong turn in viewing the reason for the treatment as having been conceded. So the Court of Appeal stance was that, well, everyone knew factually how this had come about, but the real issue was what is the correct legal characterization of the reason for the treatment. So below, the commissioner had argued, well, it's simply that she was absent and there was no entitlement to pay in those circumstances when she's exhausted her maternity pay entitlement. And although the commissioner had misconstrued the regulations, the reason for the treatment was simply that she wasn't entitled to pay, as far as the commissioner believed. And that would also be true in a case of sickness absence, for example, where the relevant officer has exhausted their sick pay entitlement. The commissioner would have also stopped London allowance in those circumstances. Point to note there, though, of course, is that the sick pay terms were significantly more generous. So the timeline of cessation of London allowance is very different in a sick pay context from a maternity pay context. But that was the argument. It was being absent. And on the other side of the coin, the argument for the claimant was, well, hang on a minute, she's on maternity leave. the Commissioner didn't take down the sick pay terms from the shelf in order to figure out when it should stop London allowance. It took down the maternity pay terms because the claimant was on maternity leave and not any other type of leave. So by definition, maternity must have been the reason. The Court of Appeal's answer was, unlike the Commissioner's actual argument and unlike the reasoning below, was to focus on the fact that there'd been a mistaken belief as to the proper construction of the police regulations. So the Court of Appeal said the cause of the treatment was the mistaken belief that the Commissioner had. So what you have to do is pretend that the mistaken belief was not mistaken. Imagine that the Commissioner was correct in its construction of the regulations. In those circumstances, if the Commissioner had been right, then this would have been a Gillespie type of equal pay claim. So you may recall that ECJ judgment says that a woman on maternity leave is not entitled to claim full pay throughout the duration of her maternity leave because she's not at work during that period and not entitled to pay, and there's no scope for an equal pay claim requiring payment in full during maternity leave. And that would effectively have been this case if actually London allowance was not due throughout the duration of maternity leave. So in effectively the Commissioner's mind, there was no entitlement to London allowance. A claim for it in those circumstances would be a Gillespie type of equal pay claim, which couldn't succeed and which couldn't be a direct sex discrimination claim. And in those circumstances, there couldn't be direct sex discrimination. And on that basis, the line of ECJ cases, Hertz, Decker, Webb, which you hopefully will have remembered from your practice or your academic days, also an EAT judgment in Fletcher, all of those cases which say that treatment because of maternity leave is direct sex discrimination, they were all sidestepped because this was treated as an equal pay case, even though it actually wasn't. So the Court of Appeal says the criterion was being absent without an entitlement to pay. It wasn't specifically being absent on maternity leave. Similar treatment would have happened in respect of leave for other reasons, e.g. Sick leave. So the fact that Mrs. Geldart happened to be on maternity leave was basically coincidental. She just happened to be on maternity leave. That wasn't the reason for the treatment. It wasn't the criterion that was applied according to the Court of Appeal. So on that basis, the issue about whether a pregnancy or maternity claim can only be made without having to compare the claimant with anybody else, with a male hypothetical comparator, that issue simply didn't arise. Court of Appeal didn't have to decide that, so the EAT judgment on that point was not overturned, and the EAT judgment can still be referred to as authority on that issue because the appeal was allowed for other reasons on the direct sex discrimination issue. The cross appeal by Mrs. Geldart was allowed, so the indirect claim is still alive. Unfortunately, as I said, because there were no findings, no conclusions about it at first instance, which could be relied upon in the alternative, there simply weren't any relevant findings at all, no reasoning, no conclusions at either ET or EAT level. So the Court of Appeal didn't really have much choice but to remit that to the tribunal. So that claim will go back to the same tribunal. I would say that in respect of that claim, there's not likely to be an objective justification defence because it's difficult to see how there could be a legitimate aim for reducing and stopping London allowance where doing that was contrary to the provisions of the police regulations. So can it ever be a legitimate aim to fail to comply with other legal obligations, I think that's a somewhat difficult argument. So whether the indirect claim will succeed is likely to turn on whether there's particular disadvantage to women. But what about the reasoning in this case? What does it mean for the law generally, and what is likely to happen in the future? How can you use it or try to avoid it in your work, in your cases? Well, I would say that there is a significant problem in Lord Justice Underhill's reasoning, because when you stop and think about it, what he has done is to confuse the mental processes behind choosing to apply the criterion with the actual application of the criterion. So he placed pretty heavy reliance on the Jewish Free Schools case in the Supreme Court, and as you saw on the slide earlier, paragraph 65 of what Lady Hale says in that judgment, to the effect that the key question in any discrimination case is what is the cause of the treatment. But what he doesn't refer to is the ensuing paragraph where she deals with the difference between criterion cases and mental processes cases. And she goes on to say that the motive for applying a particular criterion is irrelevant in a criterion case. What is important is what the criterion is and whether it is inherently discriminatory or not. And I would say here that there wasn't a dispute that the basis upon which London allowance was reduced and then stopped was the provisions of the maternity pay scheme under the police regulations. So the determining factor in deciding to cut the London allowance was the fact that the claimant had 13 weeks of maternity leave at that point. That's what the maternity pay provisions stipulated. It was that point in time that the maternity pay provisions stipulated pay should be reduced, and that is why the London allowance was reduced. Those terms are different from the sick pay terms, which provided for 26 weeks of full pay and then 26 weeks of half pay. So anyone on sick leave would in fact only have had their London allowance reduced after 26 weeks, not 13 weeks, as in the claimant's case. So, and there was no dispute about that. It's difficult to see why that specifically was not the criterion for reducing London allowance in the claimant's case. And I would argue that the motivation for applying that criterion, namely the mistaken belief that that was what was supposed to happen under the police regulations, because there was a mistaken belief that London allowance should be treated in the same way as pay, well, that motivation is irrelevant to the analysis, according to Lady Hale. So, as I say, it does create a significant problem, because the boundary now between what is a criterion case and what is a mental processes case has become somewhat blurred. How are we supposed to know when a particular case in front of us is a case of applying a criterion entailing a particular analysis for direct discrimination purposes, and how are we supposed to know when it's a mental processes case, requiring us to think about whether the particular characteristic had a material influence on the thinking of a particular person? I think that drawing that distinction has become more difficult. And in terms of the development of the law, I would argue the courts should be looking to re-establish firmly that distinction in reliance upon Supreme Court judgment in JFS and also other longer standing top-level judgments, for example, James and Eastleigh, the swimming pool entry case, which I hope you all remember. So I would hope that future appellate judgments will take care to separate out the criterion from the motivation for applying it. But in getting to that point, people have to litigate this issue, and there will be cases which arise where there may be difficulties arising out of the Geldart judgment. And what I would say is that if you're acting for a claimant in a case of this nature, the name of the game will be to try to argue that Geldart is essentially confined to its own facts, doesn't particularly translate to the circumstances of your own case. Or alternatively, you can try to frame your case as a mental processes case instead and focus on the reasoning of the individual decision maker, if there is one. If you're acting for a respondent, of course, you're going to want to focus on the motivation for applying the criterion. However, you're going to want to align your case as closely with Geldart as you possibly can. And if that catches on and courts are receptive to that sort of approach, I think that is quite damaging for the law of direct discrimination, and it casts a shadow over quite long-standing case law. So if we stop and think about the James and Eastleigh case, the swimming pool case, so you'll hopefully remember the issue was that there was a rule, free entry into the swimming pool if you're retired. So at the time, with differential retirement ages, women got in for free at 60, men didn't get in for free until 65. That is the archetypal criterion case. It wasn't about the individual decision making of any particular person. And the House of Lords famously says, well, it's an inherently gendered criterion. The reason is sex. Anyone between the ages of 60 and 65 that gets in for free will be a woman. No man between the ages of 60 and 65 will get in for free. Therefore, it's direct sex discrimination. Taking the Geldart approach, the argument would be, well, the motivation for applying that criterion was the belief that it's okay to base free entry on the statutory at the time differential retirement ages. There was no obvious necessarily correlation between that and gender, and if you apply the Geldart reasoning to the facts of James and Eastleigh, it's like saying the cause of the treatment in James and Eastleigh was the fact of not being retired. So a man between 60 and 65 who has to pay to get in, the reason why he has to pay is that he's not retired. It's not because he's a man. If you follow the Geldart reasoning to its logical conclusion, previously well understood principles in relation to criterion cases are turned on their head, and I think that is a matter of concern. I would hope that arguments of that nature by respondents will ultimately fall flat for the sake of the law, but we'll have to wait and see. So on that bombshell, I'll now hand you over to Anna, who's going to talk to you about Price and Powis concerning shared parental leave pay and direct sex discrimination.
Thank you very much, Douglas. Unfortunately, I'm having a couple of problems with my internet. I just want to check that everyone can hear me at the moment. I don't know whether anyone's possible to pop a message in the chat. Oh, Douglas has given me a big thumbs up, so we'll go with that. So as Douglas mentioned, I'm going to be dealing with the next instalment in the line of shared parental leave and sex discrimination case law, and that's the recent EAT decision in Price and Powis. Now, the facts of this case are pretty straightforward. The claimant was a male employee of the respondent. When his wife was expecting their first child, they agreed between themselves that the claimant would stay at home and care for the baby, and that the claimant's wife would return to work. In advance of that, the claimant contacted his employer and asked for information about his entitlements under the policies. apparently there was some kind of delay and that information wasn't entirely forthcoming. But when he was given that information, he essentially found out that, if we just return back to that slide, he essentially found out that the rates of pay for those on shared parental leave were lower than those on maternity leave, and as is relevant for the appeal, adoption leave. The claimant, as a result, decided not to take a period of shared parental leave and instead decided that he would bring a claim for direct and indirect sex discrimination before the employment tribunal. Now, at first instance, the claim about indirect discrimination, which it concerned the periods of delays in getting that information, was dismissed, and there was no appeal against that. So the key thing for our purpose is the direct sex discrimination. So in terms of the direct sex discrimination claim, the claimant sought to rely on two potential comparators. The first was a female employee on maternity leave, and because of the case of Ali and Capita, which I'll come on to address in a moment, that was dismissed. The second proposed comparator was a female employee on adoption leave. And again, at first instance, the tribunal rejected that argument, and that was largely for similar reasons as they rejected the female comparator in respect of the maternity leave. The claimant appealed to the EAT on three grounds. One of those grounds was predicated on permission to the Supreme Court in Ali and Capita being granted. Because that was refused, that appeal ground fell away. So the final two grounds of appeal concerned essentially different ways of arguing that the employment tribunal erred in finding that a female employee on adoption leave was not an appropriate comparator for this claim. Now, this was given relatively short shrift in the employment appeal tribunal. The tribunal found first that it wasn't the case that adoption leave and shared parental leave shared the same predominant purpose of facilitating childcare. The Employment Appeal Tribunal found that while that was a purpose of both adoption leave and shared parental leave, adoption leave went much further than that. It dealt with health and safety. It dealt with the need to cement a parental bond, which might be more difficult or more complex in adoption cases. It also dealt with the need to take steps to prepare for maintaining a safe environment for the adopted child to enter the family. It then also dealt with the arguments about the fact that the tribunal had taken into account irrelevant or immaterial matters in coming to its conclusion that proposed comparator was not in materially the same position. The matters that the tribunal had relied upon, it included the fact that adoption leave could not commence prior to the placement. The adoption leave could commence prior to the placement of the child, which was not the case for shared parental leave. That adoption leave was an immediate entitlement upon the placement of the child. That shared parental leave could only be taken with the mother's agreement, and adoption leave was distinguished on the ground that at the time at which the partners elect which one of them will be the adopter for the purposes of the statutory entitlement, neither of them had that entitlement to begin with. It was only once it was the election had taken place that that entitlement was conferred upon them. And also that shared parental leave can be taken within the 52-week period and can be dipped in and out of. There's a certain level of flexibility, which in the Employment Appeals Tribunal's view linked into this purpose of shared parental leave as facilitating childcare and facilitating choice. The one point in which they did criticise the first instance tribunal was that the first instance tribunal had made some references to adoption leave being compulsory, which they found was not the case, but they found, taken into account the different purposes of adoption leave and shared parental leave, and indeed the fact that the other factors which the tribunal had taken into account were relevant and material, that didn't affect the outcome. And I think that largely comes down to point 3 on the slide. the point that the more appropriate comparator would have been a female employee on shared parental leave, and that's at paragraph 55 of the judgment. And I think this is really the reason why, if this wasn't entirely doomed from the start, it was always going to be a massively uphill struggle. And this comes from the Court of Appeals judgment in Ali and Capita itself, which is referred to at paragraph 74, where it talks about the fact that the most appropriate comparator would have been a female employee on shared parental leave. Therefore, as a matter of precedent and indeed principle, it was difficult to see how relying on an employee on adoption leave was ever going to get around that. Whichever way you slice it, whether you think that the reasons given by the Court of Appeal and adopted by the Employment Appeal Tribunal in Price about the differences and the special purpose of maternity leave in particular and adoption leave in the Price case, you're always going to fall back on the fact that an employer can point to the fact that there could have been, or indeed in some cases was, a female employee that they would have or did treat in exactly the same way, and that would be a female employee on shared parental leave. On that basis, it seems that it's no longer going to be possible to run a case of direct sex discrimination in these circumstances. Bearing that in mind, I'm just going to go on to talk about the sister case to Ali and Capita, which deals with the indirect sex discrimination alternative. And as everyone will be aware, this is another one in which Douglas was involved. So Hextall was brought as an indirect sex discrimination claim. At the Court of Appeal level, it was in fact held, though, that this was, according to the Court of Appeal, in reality an equal terms case. And that has the following consequences. First, that it's not possible, according to the Court of Appeal, to bring an indirect sex discrimination claim in these circumstances. That's barred by Section 70 in its entirety. And further, that a sex equality clause will not avail a claimant in these circumstances because of Schedule 7.2, which says that a claimant cannot rely on a sex equality clause allowing for special treatment related to childbirth and apologies if I just related to pregnancy or childbirth, to use the correct terms. They further went on to say that even if there were an indirect sex discrimination available, which they said was not the case because of Section 70, such claims would not succeed. And they gave various reasons for this in relation to the correct pool, but pertinently for our purposes, they also talked about the fact that despite the fact that there is no equivalent to Section 7.2 in respect of indirect sex discrimination in the Equality Act, they would have gone so far as to read that bar into the Act itself. So what then does this mean for shared parental leave claims? Does this mean that they are essentially no hopers anymore? I think that's not necessarily the case, and I'm going to explore a potential option for claimants in the position as the claimants in the case of Price and the other cases which I've discussed. This factual pattern raises human rights issues. In particular, it raises a question about Article 8, which protects, among other matters, the right to a family life, and as well Article 14, which concerns non-discrimination. It also potentially engages Article 13, which is the right to an effective remedy. The idea being that if the state has discriminated against you or allowed someone to discriminate against you, but then says there's no way in which you can recover in respect of that, that may also be a breach of the European Convention on Human Rights. The particular point to note in respect of Article 13 is that it's not in the schedule appended to the Human Rights Act, and as a result it wouldn't be possible to rely directly on Article 13 in the domestic context, but it might be relevant to an issue before the Strasbourg court. The point then to consider is how we proceed or how we deal with that possibility. The starting point is always to consider whether or not it's we're dealing with a state or a non-state employee. If we're dealing with someone who's employed by the state, then Section 6 renders it unlawful for any public authority, which it could include a public employer, to act in a way that's contrary to the convention. So there may be a more direct route in respect to someone who is employed by a public employer as opposed to a private one. But if, of course, we are dealing with a private employee, or indeed as a way of bolstering the claim of a public employee, then the remaining options to consider are Section 3 and Section 4 of the Human Rights Act. Section 3 deals with the duty on courts and tribunals to interpret legislation so far as possible, and I think those are probably the key words here, in accordance with the convention. In light of the reasoning given by the Court of Appeal and indeed the words of the Equality Act itself, there's going to be a real struggle to convince a court or tribunal that the way that they should be reading the provisions of the Equality Act is in a way that would allow a claimant to bring a claim in these circumstances. In particular, I'm thinking about equal terms or indeed indirect sex discrimination. This is particularly important given that the Court of Appeal expressly recognised in its judgment in Hextall that one of the purposes that it identifies of the Equality Act is to preserve special treatment of women on maternity leave, and therefore a reading of the Equality Act and the Court of Appeal's interpretation of that, which goes directly contrary to what it sees to be the policy, may be something that is quite difficult, if not impossible, to convince a court or tribunal to go along with. That then leaves Section 4, which is the Declaration of Incompatibility. Now, it's important to be borne in mind that only certain courts and tribunals can make declarations of incompatibility, and furthermore, that there's no real guarantee from that as to what the outcome will be. There's no binding obligation on Parliament once the Declaration of Incompatibility is made to do anything in particular about it. Now, that's not to say that they wouldn't do something about it, but of course there's no guarantee and there's no obvious remedy for an individual claimant in those circumstances. That does raise a quite interesting question about how that interacts with the duty prior to going to Strasbourg to exhaust domestic remedies. You will, I think, probably be aware of the fact that there are certain procedural requirements before presenting a claim to Strasbourg, one of which is that the claimant must exhaust domestic remedies. But that obligation only goes so far. It's only an obligation to exhaust effective remedies. It's therefore important to note in a very recent case decided of March this year, MC in the United Kingdom, so on the 31st of March 2021, that the Strasbourg Court has reiterated that it's not persuaded that a declaration of incompatibility would have afforded a claimant an effective remedy, because it hasn't accepted that there is a practice in the United Kingdom of giving effect to declarations of incompatibility so as to impose binding obligations on Parliament to do something about it. And as a result, in that case, there was no failure to exhaust domestic remedies in circumstances where the court accepted that that's the only thing that the claimant could have done. So it's an interesting question whether it may not be possible, now that it's quite clear what the law is, to jump straight to Strasbourg, although it is often likely to be the case that exhausting domestic remedies, going to a domestic court in the first instance will be the safest option. Considering then briefly what an application to Strasbourg might look like, again, it's important to distinguish between public and private employers. In respect of a public employer, the claim would essentially be that the state, through the public employer, has failed to respect the employee's private life and discriminating against them. However, that discrimination is conceptualized in not affording them equal pay in respect of a period of shared parental leave. And that the state has then gone on to, in respect of Article 13, not allow them to bring any kind of claim about this. And that's in particular in relation to the very absolute reasoning in the Court of Appeal that because it's an equal pay claim as they conceptualize it, there's a bar to it under Schedule 2, and indeed also that they would view there being a bar in respect of indirect sex discrimination. There's no room for balancing or proportionality. It's no, you can't bring it. And that would be the sort of the nub of the case. And in relation to a private employer, it would be slightly differently phrased. It would essentially be that the state had failed to sufficiently protect their right to a private life, and within that to not be discriminated against, and then later not afforded an effective remedy in respect of that failure. It is obviously an open question whether or not an international court like the European Court of Human Rights, which affords a margin of appreciation to many of its member states, which may have different conceptions of the way in which family life should be appropriately protected within their jurisdictions, is going to go so far as to say that this is a violation. But if the question is there no future for shared parental leave claims, I think that to say no, there isn't would be going one step too far. So on that note, thank you very much for listening. And are there any questions about either the cases that I've discussed or indeed that Douglas has discussed?
I can see that somebody has raised their hand, metaphorically speaking, in the chat. So I don't know if that person would like to ask a question. I mean, we can take questions via the chat mechanism, or alternatively, please feel free to unmute and speak your mind. Very happy to discuss issues arising out of those cases. Seems there is a paucity of questions, so that must mean that the talk was so comprehensive that all the conceivable questions have been answered already. But I think once the meeting is closed, the chat function remains open for some time. So if questions occur to you after having logged out, then do feel free to pop them in the chat function, and we can look back in and answer them over the next day or so. Or feel free to contact us in Chambers via email or telephone if you want to ask anything. And particularly if anybody has a shared parental leave case which might have the backing of, say, a union of some description, and which the union is keen to pursue to Strasbourg, then obviously we'd be very interested to hear from you and test out Anna's arguments. I think that it has been done before in a way, in that you may remember the Eversheds and DeBellin case in the EAT, where Mr. Justice Underhill, as he then was, said that Section 13, subsection 6, which is a similar sort of defence provision, equivalent provision to Schedule 7, paragraph 2, does the same job, and just says that special measures in protection of maternity are ring-fenced and can't be the subject of a direct sex discrimination claim. Well, he said in that case that he read into that provision a test of proportionality, and that is effectively what the human rights argument would do, it seems to me, is to replicate that concept on a human rights footing, a convention footing. And you'd be saying, well, the law, the Equality Act, is defective in the sense that it's absolutist and provides no scope for nuance or different outcomes in different cases. So it's an interesting proposition, and as Anna says, it's the route that's still available. So yes, very keen to hear about shared parental leave cases of that sort. And sex discrimination cases generally, but it doesn't seem that there is any burning question apart from can we have a copy of the slides. Yeah, I don't see why that shouldn't be possible.
I think this is going to be made, the recording of this is certainly probably going to be put on the website, and I imagine we will probably also pop a copy of the slides there as well. So hopefully that will be accessible within the next few days.